An LLC is formed by filing articles of organization, usually in the Secretary of State office. The owners are known as members. Their liability is limited to the amount they invested in the business. The earnings of the LLC are taxed as a partnership. The operating agreement is the most necessary document for an LLC. They are similar to the bylaws of a corporation, but more detailed. It is not required by all states for LLCs to have an operating agreement, but it is a very good idea even if the LLC has one member. The operating agreement should cover a variety of different things. One is the assignment of percentages of ownership. The percentages of ownership should be assigned according to the value of capital contributions. This is only the case if members do not assign the percentages in their agreement. Another is the assignment of distributive shares, meaning members can allocate each member's share of profits and losses and see if they fit. A third thing is the voting rights in the company. These reflect the members' choice between having a vote or if they have voting power proportional to their capital investment percentages. A fourth is the members' rights and duties. It should specify which members have the power to bind the LLC contracts, possession, and use of LLC property. A fifth is the prohibitions on sales of interest in the company. Any restrictions on members selling their investments should be explicitly stated in the agreement. A last is termination of the ownership interests. It should specify the procedure on how to value and buy out interest of members who die, retire, or withdraw. For other reasons, it should be specified in the operating agreement. The articles of organization should include the name of the business, the nature of the business, the office address, the agent for service of the process, the name and address of organizers, and the names of initial LLC members. Some advantages of LLCs are: there are no limitations on the numbers of members. There are no limitations as to whom or what can be a stockholder in an LLC. Foreign nationals, corporations, and other businesses can be shareholders. Members can participate completely in managing the business. These make LLCs more attractive than other small business forms. It is the ideal form for most small businesses. One relative disadvantage only impacts people who encounter the problems in transferring assets from a partnership or other types of corporations to the LLC. The perks of the LLC are so suitable to small businesses that it will be presumed by the IRS to want to be treated as an LLC. Some examples of LLCs are Buffalo Web Services, Vertasource, Even House Printing, Benecare Agency, Sheridan Benefits, Green Payroll. Another example of an LLC is Lally Benefits Group Insurance. Some facts about this insurance are: a limited liability company is recognized as a separate legal entity from its members, as is Lally Benefits Group Insurance. This LLC is not required to hold regular meetings of its members. Typically, management and control of this LLC is assumed by its members and, therefore, does not require a board of directors. Voting rights usually correspond directly with the members' interests and profits. Members in this LLC cannot be transferred or new members admitted without the consent of the majority interest. Traditionally, this LLC has a limited life, which is usually about 40 years or on the death of a member. A member may be a non-resident alien. This means he does not pay U.S. taxes on income not delivered to the U.S. through business or trade. Non-resident aliens can fully own a limited liability company. A LLC requires an operating agreement. An operating agreement may be verbal or in writing, as Lally Benefits Group Insurance has.